You spent years building something, a house, a retirement account, maybe a life insurance policy worth more than everything else you own combined. You hired a lawyer, you signed a will. You told your kids exactly who gets what. And then, without knowing it, you signed one other piece of paper. A small form, maybe 2 pages. Maybe you did it online in under 3 minutes. And that one form, that one document you probably forgot about the moment you submitted it, will override your will entirely. Your kids will get nothing. Not because of a legal battle, not because of a contested estate, not because someone cheated them, because of a beneficiary designation form. Now here's where it gets strange. This isn't a new trap. It isn't some obscure 2026 tax code update buried in 900 pages of legislation. This mechanism has existed for decades. Lawyers know about it. Financial advisors know about it. And yet, every single year, hundreds of thousands of families discover it the hard way, sitting in a probate attorney's office 6 weeks after a funeral, wondering why the money went to the wrong person. Today, we're going to find out why. And we're going to follow the money all the way back to the origin of this system to understand how something designed to protect families became one of the most quietly devastating estate traps in American financial history. Stay with me, because the story is stranger than you think. To understand the beneficiary designation trap, you have to understand something fundamental about how wealth is actually held in America. Most people think their will controls their money when they die. And that's true for some of their money. Furniture, a car, a personal bank account with no designated beneficiary, those assets go through probate, a court-supervised process where the will is read and assets are distributed accordingly. But there's a second category of assets, and this is where things get complicated. Retirement accounts, your 401k, your IRA, your Roth IRA, life insurance policies, annuities, pension plans, payable on death bank accounts, transfer on death brokerage accounts. All of these assets pass outside of probate. They don't care what your will says. They transfer directly, automatically, to whoever is listed on a form you likely filled out years ago, possibly the first day you started a new job, sitting in an HR office, staring at a stack of papers you'd never seen before. That form asked you one question. Who gets this money if you die? And here's the thing most people don't realize. Whatever answer you wrote down that day, that answer is still in effect, today, right now, no matter what has happened since. You could have gotten divorced, remarried, had 3 more children, written and rewritten your will 4 times. You could have specifically written your ex-spouse out of your estate with language so precise a federal judge couldn't argue with it. None of that matters. If that old beneficiary form still has your ex-spouse's name on it, they get the money. This is not hypothetical. This is not a rare edge case. This is one of the most common and most devastating financial mistakes in the country. But to understand why the system works this way, and why it isn't going to change anytime soon, we need to go back to where this all started. The year is 1974. America is coming out of a period of economic turmoil. Inflation is rising. Workers are worried about retirement security. And Congress is about to pass one of the most significant pieces of financial legislation in American history, the Employee Retirement Income Security Act, ERISA. ERISA was designed with genuinely good intentions. Before 1974, company pension plans were often mismanaged, underfunded, or outright raided by employers. Workers would spend 30 years at a company expecting a pension, and then find out the day they retired that the fund had been looted. There was essentially no federal protection. ERISA changed that. It set standards for pension plan funding, created fiduciary responsibilities, and, crucially, introduced a mechanism called the named beneficiary system. The idea was elegant, simple, efficient. Instead of routing retirement assets through probate, a process that could take months or years and eat up a significant portion of an estate in legal fees, workers could designate beneficiaries directly. The money would transfer automatically, immediately, without a court touching it. It protected families. It was faster. It was cheaper. It was, by almost any measure, a massive improvement over the alternative. And for a while, it worked exactly as intended. But ERISA also created something it didn't fully anticipate, a parallel financial universe that operated entirely outside the traditional legal framework of estate law. Here's what that means. When you write a will, it operates under state law. When a beneficiary designation is on file with a financial institution, a 401k administrator, a life insurance company, that designation operates under federal law or under the specific contractual terms of that financial product. The two systems were never designed to talk to each other. They were built in parallel. And for decades, that gap, that silent, invisible gap between your will and your beneficiary forms, has been swallowing family wealth without a sound. Through the 1980s and 1990s, something dramatic was happening in American finance, the 401k, which had been created almost by accident in 1978 as a tax provision in the Revenue Act. suddenly became the dominant retirement vehicle in America. Companies began shifting away from traditional pensions. They didn't want the liability. The 401k shifted the burden and the responsibility to individual workers. By 1990, there were approximately 19 million 401k participants in the United States. By 2000, that number had grown to over 42 million. And every single one of those participants filled out a beneficiary designation form. Most of them filled it out once, on day one of a new job, when they were 24 years old, had no children, no significant assets, and probably cared more about where they were going for lunch than the details of their estate plan. But now those accounts were growing. 20 years of market appreciation, employer matches, compound interest. The account that had a few $1,000s in it when the form was filled out now had a few $100,000 in it. And the form, that forgotten 2-page document sitting in a filing cabinet at a financial services company in Ohio, still said the same name it had always said. Sometimes that name was a college girlfriend. Sometimes it was a parent who had since passed away. And sometimes, in the most common and most heartbreaking version of this story, it was a first spouse, an ex-spouse, someone the account holder had divorced 15 years ago, moved on from, remarried, and built an entirely new life away from. And here's where the story gets genuinely dark. Because in many states, when you get divorced, your will is automatically updated to remove your ex-spouse. Divorce severs their inheritance rights through the traditional probate process. But your 401k, your life insurance, your IRA, in most cases, they are completely unaffected by your divorce. The Supreme Court addressed this directly in the 2001 case, Egelhoff vs. Egelhoff. William Egelhoff divorced his wife Donna and was then killed in a car accident before he updated his 401k beneficiary designation. His kids from a prior relationship argued that Donna should be cut out. There were state laws in Washington that automatically revoked beneficiary designations upon divorce. The Supreme Court ruled against them. Because ERISA is federal law, it preempts state divorce revocation statutes. Donna got the money. The children got nothing. That ruling sent shockwaves through the estate planning community. But it barely registered with the general public, and the accounts kept growing, and the forms kept aging. Let me tell you about the moment the trap actually closes. It happens in the weeks after a death. The family is grieving. There's a funeral to arrange. There are condolences to receive. And then, when the emotional shock is just starting to ease, someone has to deal with the financial accounts. This is when the discovery happens. The surviving spouse calls the 401k administrator, or the life insurance company. They provide the death certificate as instructed, and then they wait. And then they get a letter. The letter explains that the proceeds have been dispersed to the named beneficiary on file. And the named beneficiary, the letter clarifies, is someone who is no longer part of this family's story. An ex-spouse, a deceased parent whose estate has long since been settled, a sibling the deceased hadn't spoken to in a decade. The money is already gone. And here's the cruelest part of the legal reality. There is almost nothing that can be done. The financial institution followed the law perfectly. They paid exactly who the form said to pay. Courts are extremely reluctant to override a beneficiary designation because to do so would undermine the entire efficiency argument that makes the system valuable in the first place. In rare cases, cases involving fraud, undue influence, or documented incapacity, courts have intervened. But those cases are the exception, not the rule. For the vast majority of families, the discovery is the end of the road. And the numbers behind this are staggering. According to data from the Investment Company Institute, Americans held approximately $38 trillion in retirement assets as of 2025. That's retirement accounts alone, not life insurance, not annuities, not payable on death accounts. $38 trillion. All of it governed by forms that an unknown, but certainly enormous, percentage of holders have not reviewed in years. Financial planners commonly estimate that between 30 and 50% of their new clients have a beneficiary designation error. Outdated names, wrong people, sometimes no beneficiary at all, and which means the account goes through the estate anyway, defeating the entire purpose of the system and triggering probate costs the family was specifically trying to avoid. The legal fallout from beneficiary designation errors has been quietly building for decades. Courts across the country have grappled with the problem. Some states have tried to legislate their way out of it. Many have passed laws requiring financial institutions to notify account holders to review their beneficiaries after major life events. A handful of states have attempted to pass automatic revocation statutes for retirement accounts, similar to what exists for wills. Most of those state statutes have been struck down under ERISA preemption, the same principle the Supreme Court applied in Egelhoff. Congress has tried, too. In 2019, the Secure Act made significant changes to retirement account rules, most notably eliminating the stretch IRA strategy that allowed non-spouse beneficiaries to extend distributions over their lifetime. But it didn't touch the core beneficiary designation mechanism. The Secure 2.0 Act, passed in 2022, made further adjustments to required minimum distributions and added new flexibility provisions. Still, no mandatory review requirements, no automatic divorce revocation for federal retirement accounts, no systemic fix for the form problem. And why not? Because fixing it is genuinely complicated. Financial institutions process millions of beneficiary changes every year. Adding a mandatory review system or implementing automatic revocations tied to life events would require coordination between financial institutions, courts, government agencies, and state vital record systems. It would require federal legislation that overrides decades of established practice. It's not impossible. It just requires political will that, so far, has not materialized. In the meantime, families keep discovering the trap the same way they always have. Too late. Here's why this story matters more in 2026 than it ever has before. 3 trends are converging right now, and together, they are setting up a wave of beneficiary designation disasters unlike anything we've seen before. The great wealth transfer is accelerating. Over the next 20 years, an estimated $84 trillion in assets will transfer from baby boomers to their heirs. This is the largest intergenerational wealth transfer in human history. Much of that wealth is sitting in retirement accounts, the exact type of asset governed entirely by beneficiary designation forms. The stakes have never been higher. Second, the divorce rate for people over 50 has doubled since 1990. What researchers now call gray divorce, the dissolution of long-term marriages in middle age and beyond, has created an entirely new population of people with potentially dangerous beneficiary designations. These are people who accumulated significant retirement wealth during their marriages, divorced after 50, and may not have updated their financial documents with the same diligence their attorneys applied to the will and the property division. Their retirement accounts, often the largest single asset in the estate, may still name the person they spent years divorcing. Third, the gig economy and job-hopping culture has created a sprawling landscape of forgotten accounts. The average American worker now holds more than 12 jobs before retirement, according to Bureau of Labor Statistics data. Each job with a retirement plan means another beneficiary form, another account, another set of documents sitting at another financial institution. And when people change jobs, especially when they're young, especially when the account is small, especially when the rollover process feels optional, those accounts sometimes just sit there, dormant, growing, waiting. A 28-year-old who opened a 401k at her first job, named her then-boyfriend as beneficiary, changed jobs, forgot to roll over the account, and now has $47,000 sitting at a financial institution she hasn't logged into since 2019. That $47,000 is not going to her husband, her children, or anyone she intends it to go to. That $47,000 is going to a man she dated for 8 months when she was 22 years old, and she doesn't know it yet. This is the part of the story where most videos give you a list of 10 things to do and you do none of them. So I'm giving you 3, just 3. But these 3 things, done properly, can prevent exactly the catastrophe we've been talking about for the last 20 minutes. Takeaway 1, run a beneficiary audit. Right now, not next month. Every financial account you own that carries a beneficiary designation, your 401k, your IRA, your Roth IRA, your life insurance policy, your annuity, your payable on death bank accounts, your transfer on death brokerage accounts, needs to be reviewed. Not summarized, not assumed. Actually opened, actually logged into, actually confirmed. Make a list of every account. Log into each one. Look at who is named as the primary beneficiary. Look at who is named as the contingent beneficiary. The contingent beneficiary, the backup, is just as important as the primary. Because if the primary beneficiary predeceases you and you haven't updated the form, the contingent steps up. And if there's no contingent, in many cases, the money goes into your estate and through probate anyway, defeating the entire purpose. Write down what you find. Cross-reference it against your will, against your current life situation, against who you actually want to inherit this money. This process should take 2 to 4 hours. It is 2 to 4 of the most financially important hours you will ever spend. Takeaway 2. Coordinate your beneficiary designations with your estate plan and use a professional to do it. Beneficiary designations don't exist in a vacuum. They need to work in harmony with your will, your trust documents, if you have them, and your overall estate strategy. There are situations where naming an individual as your beneficiary is the right call. There are situations where naming a trust as your beneficiary makes far more sense, particularly if you have minor children, a beneficiary with special needs, or concerns about a beneficiary's ability to manage a sudden influx of wealth responsibly. There are also tax implications. Non-spouse beneficiaries who inherit retirement accounts are now required under Secure Act rules to deplete those accounts within 10 years. Depending on the beneficiary's income, that could trigger significant tax liability. A trust structure can sometimes mitigate this, but only if it's set up correctly and named correctly on the beneficiary form. This is not a DIY situation. Hire an estate planning attorney who works specifically with retirement assets. The cost of a proper review and update is a fraction, a tiny fraction, of what it costs families when the forms are wrong. Takeaway 3. Build a review trigger into your life and your calendar. The beneficiary designation problem is fundamentally a maintenance problem. People set it and forget it. And they forget it because nothing in the system reminds them to update it. So you have to build the reminder yourself. Add a recurring calendar event every 2 years, every year if you're in a period of major life change, that says review beneficiary designations and attach specific life triggers to it. Get married? Review immediately. Get divorced? Review within 30 days, especially your retirement accounts. Have a child? Review. A beneficiary dies? Review the same week. Change jobs? Before the new 401k is even fully enrolled, write down the old account and schedule the rollover and the update. Treat this the way you treat renewing your car registration or filing your taxes. It's not exciting. It's not optional. Here is the uncomfortable truth that this entire story has been building toward. The beneficiary designation system was built to help families. And in many ways, it does. It moves money quickly. It avoids costly probate. It delivers assets directly to the people who need them, often within weeks of a death. But the system was built for a world that no longer exists. A world where people worked one job for 30 years, where marriages lasted a lifetime, where beneficiary forms were reviewed at retirement right before the money was actually needed. We live in a different world now, a world of constant change, multiple employers, evolving family structures, and financial complexity that most people were never taught to navigate. And the form hasn't adapted. The mechanism hasn't changed. And the gap between what people intend and what the paperwork says, that gap is wider than it has ever been. Here's the question I want to leave you with. We have systems that automatically update your credit score when your financial behavior changes. We have systems that instantly flag suspicious transactions on your debit card. We live in an age of real-time data and automated alerts for almost everything that touches our money. So why, in 2026, does the most important financial designation you will ever make still operate on a paper form that hasn't been touched since you were in your 20s? That's not a rhetorical question. It's a real one. And the answer, when you look for it, says a great deal about who benefits from the system staying exactly the way it is and who loses. Think about that. If this video gave you something to think about, or better yet, something to do, hit subscribe. We cover stories like this every week. Not the obvious ones, not the things everyone's already talking about, the quiet mechanisms, the systems running in the background, the forms you signed and forgot, because the most dangerous financial traps are never the ones that announce themselves. They're the ones that look like paperwork. Leave a comment below. Have you done a beneficiary audit? Did you find anything surprising? I read every comment, and your experience might be the thing that prompts someone else to check their forms. Share this video with someone who should hear it. You probably already have a specific person in mind. And if you want to go deeper on estate planning, retirement accounts, or the Secure Act, changes affecting your beneficiaries right now, the next video is right there. I'll see you in it.